Hey there, my name is Tara Marie. Welcome to my channel where we talk about and analyze everything true crime. And one of the things I have done here for actually years now is analyze the Scott Peterson case. So I'm going to have a couple of these coming out because really, as many of you probably know, on January 17th of this year, 2024, the LA Innocence Project shocked the world by filing a near 1,000-page motion declaring that they were representing Scott Peterson, who was found guilty of unaliving his pregnant wife and child in 2002, saying that they were investigating Scott's claim of actual innocence and that Scott's state and federal constitutional rights were violated. In the motion, the key requests from the LA Innocence Project's team were for the DA to allow them access to specific evidence from the time of trial, which they say Peterson has never had access to in over 20 years. They are also requesting access to certain pieces of evidence they wish to do DNA testing on. Now, I have already covered that initial motion at length. In fact, I put out a 4-part series that I'll link down below this video. It contains lots and lots of evidence never heard before, as well as new declarations just made by people involved in the case. So if you haven't seen those, I highly suggest that you go back. I'll link down below to those videos so you can kind of get caught up and then jump back to this video as I'm recording this May of 2024. But for this video, I just wanted to go over what has happened in the meantime, so you can be caught up for the next hearing on May 29th. So after that initial motion was filed, the court has now had 2 hearings as of the time I'm recording this. The first hearing we did a video on, and I can also link that down below, but that was on March 12th, and it was just a status hearing, really just to go over and set dates for the court to adhere to. The second hearing was a few weeks ago on April 16th, and that was regarding the motion to seal some names of people mentioned in the LA Innocence Project's motion. Now, that motion to seal hearing really didn't change much. The parties just agreed that the LA Innocence Project would just withdraw a particular redacted exhibit, which they believed was the simplest solution.
The motion to seal that's before the court is pretty straightforward and simple. Mr. Peterson is seeking to keep private certain witness information that was obtained from police reports for all of the reasons stated in our pleadings. So unless the court has any questions for us, we're prepared to submit on our pleadings, and we would respectfully ask for an opportunity to respond to any arguments the prosecution may raise today.
Okay, that's fine. You'll get an opportunity to reply. I guess the question that I have is every version of the exhibit, the one that was attached to your motion to seal and the one that was attached to the 1054.9 motion that is the target of the motion to seal, were filed with the court redacted. What is it exactly that you're seeking the court to seal, since everything that is in the record already has the redactions that you're looking for?
We're just asking for those redactions to be kept in place so that that information is not made public.
Okay, thank you. Comments by the people?
Your Honor, good morning.
Good morning.
I'll be brief. The language in their motion makes it unclear what they're asking for exactly, because on page 4, line 21, they write, defendant Scott Peterson is asking this court for permission to file certain information under seal and a redacted exhibit that is public-facing in support of his motion for post-conviction discovery. The motion further states the redactions cover personal identifiers of witnesses, potential suspects, individuals with knowledge of potential suspects, and other sensitive information related to counsel's investigation. This seems to suggest more than just the November 14th letter, since both the motions and the multitude of exhibits attached to both motions contain redactions or omit information up to and including the point of having anonymous witnesses. Further, what we viewed as a potentially very vague and therefore expansive request also asks the court to permanently seal the items. This is evident in Mr. Harris's statement to the court when we were here last, where he said, as of this hearing, and it remains true today, we don't know who these witnesses are. This includes DM, ST, KM, KW, TS, and KD, assuming I have those letters correct because some of the redactions were such that it was kind of hard to see the letters. So this remains our concern. In his reply, the defense attacks the prosecution at one point and essentially accuses the people of lying to this court about witnesses who have not been identified to the people. That was at page 2 of their reply on line 10. Yet it was in fact counsel who stated, the identity of the witnesses whose names are redacted in the declarations that Mr. Harris is referring to have stated they are fearful of retaliation by the Modesto Police Department if their names become known, and have asked that their names remain sealed. That's at the transcript on page 15. We just wish to ensure that in responding to these motions with very lengthy attachments, that we're able to address in a very fulsome way all of the various allegations being made in those documents. Further, as we've noted, they have requested redactions in that letter of 40 individuals and 2 addresses. Of those, 10 individuals and 2 locations are actually identified in the defense filings or their informal discovery requests. So a full 25% of those people, their names are already out there. Almost immediately upon the time of their filing, all of those documents were published by the media. So the information is out there. It begs the question how serious they are about protecting the names of these people, given that, at least outside of the people whom they only identify by initials. So there's a simple solution to that. If the concern is sealing of that particular letter, that particular letter as an exhibit could be withdrawn from the motion. It does not add to their motion. It's not necessary to their motion. It largely provides the same information as what is contained in their motions, and it also injects a lack of clarity, since frequently what is suggested in the footnotes regarding what the content of the exhibits will be is not necessarily what is actually provided in the motion and the attached exhibits, and contains a vast amount of irrelevant statements. So the defense's actions also speak to the seriousness of this motion. They now claim that the people are wrong, that the California Rules of Court 2.550 and 2.551 govern this motion to seal. That's in their reply at page 4, line 3, when it was the defense that filed this motion in the first place, stating this motion is made pursuant to California Rules of Court 2.550 and 2.551. The defendant does admit in his reply in a footnote that Mr. Peterson's motion to seal cited California Rule 2.550, 2.551, not that it was made pursuant to those sections. This sort of hit-and-run approach deprives the people of really understanding on what basis the defendant is claiming the legal right to seal anything. Instead of starting over, they just simply say, well, oops, and move on. Even under the defendant's new position, however, those rules are a good starting point. I would like to address one comment in defense counsel's motion that we have refused to provide any discovery to which they are entitled, is the claim. And I'd just like to note that current counsel substituted in and replaced prior habeas counsel on the pending habeas on November 13th of 2023. The next day, they sent us an email with the 50-plus page letter at issue here, requesting literally hundreds of items, the bulk of which had been either previously provided to prior counsel or no longer existed due to being affiliated with unrelated cases and the passage of 20 years, or never existed in the first place because their existence is based on supposition and speculation. And in addition to that, there was a request for DNA testing. So this letter arrived the week before Thanksgiving and the Christmas holidays. On December 14th, we suggested a meeting with them in January, and on January 17th, we were served with the motions at issue here. We have continued to review the various requests in these very lengthy motions as we work on our responses. This is an incredibly time-consuming process. And this is not the first time that the defense has brought such motions. He's previously brought both a 1405 and a 1054.9 motion. So in sum, our suggestion is simply to withdraw that letter from the discovery motion. Then no sealing discussion is even required. 2, we don't believe the defense has established good cause by substantive evidence for their request, because there's no substantive evidence included. But the fact of the matter is, Your Honor, we don't really have a concern with having the pleading documents have initials for these citizens who've not been previously identified, because we know who they are. We do, however, request full disclosure of the unnamed witnesses who we have no idea who they are.
Ms. Mitchell, your reply to the people's comments.
Thank you, Your Honor. Mr. Peterson has 2 objectives. One is to get the discovery and the DNA testing that we're requesting as soon as we possibly can. The second objective is to protect the integrity of our investigation that is ongoing. The motion to seal I did not expect it would be this convoluted. I agree with Ms. Vladiger that it makes sense to withdraw the exhibit at this point. We don't need it. We're entitled to our discovery without it. So to simplify things and keep things moving forward, hopefully expeditiously, we will withdraw that at this time.
Okay.
However, the next hearing upcoming on May 29th, that hearing is anticipated to be much more involved. And that is because on April 24th, the Stanislaus County DA's office finally submitted their written reply to the LA Innocence Project request for DNA testing. And man, were they opposing every single request, not surprisingly, because they say no further testing is necessary, among other things. Now, Scott's team was requesting testing on 17 items, and 4 of those were associated with a burned van found with a bloody mattress inside, which was found very close to the Peterson residence, just 12 hours after Laci went missing. In their more than 300-page filing, Birgit Vladiger and Special Prosecutor David Harris, who have both come out of retirement to respond to these requests, rejected all of those requests, mainly claiming that there was overwhelming evidence of Scott Peterson's guilt in this case. They addressed all of the items the defense is requesting DNA testing on, and they claim these items have either already been tested, litigated, are unrelated, or the burden has not been met to retest them. They stated that Scott's recent legal maneuver was cobbled together, and there was no valid new evidence. They assert that testing for DNA would not raise a reasonable probability of a different outcome and would just subject the victim's family to more grief and hardship. They wrote, "The people asked this court to deny all of the defendants' requests for DNA testing. Defendants' resulting theory is based entirely upon conjecture and speculation. The DA's position is that the Medina burglary, which occurred across the street from the Petersons' home, the same time frame that Laci went missing, is completely unrelated to the case. They also claim that a Croton watch, which was the type of watch Laci wore, which has never been accounted for, yet was later found pawned close to the Peterson home days after her disappearance, was also unrelated, they say. Finally, they claim that the burned orange van with the blood-soaked mattress was also unrelated to Laci's disappearance. Yet the DA admits in the very same document that the blood-stained mattress found in that burned orange van is a, quote, unsolved crime. Regarding the claim that the LA Innocence Project says exculpatory evidence was suppressed, the DA says, their motion makes it clear that none of the orange van items were secured in connection with a case where somebody was incarcerated in connection with that case. Peterson has never been charged with arson or auto theft, and on the record before this court, neither has anyone else. The orange van investigation is therefore an unsolved crime. In cases where no more can be said than that the evidence could have been subjected to tests, the results of which might have exonerated the defendant, the failure to preserve the evidence will not constitute a denial of due process unless a criminal defendant can show bad faith on the part of the police. There can be no violation where police act in good faith and in accordance with their normal practice without animus toward the defendant or in a conscious effort to suppress exculpatory evidence. Therefore, the presumptions the defense attempts to use as a substitute for evidence are insufficient. Now, I am definitely not a legal professional. I just read these things. So please, I always say, do your own research and form your own opinions, please. But to me, that statement almost seems like the DA is kind of laying the groundwork to protect the Modesto Police Department and themselves for any claims that they purposefully suppressed exculpatory evidence, pointing out that the LAIP can't claim Scott was denied due process if they can't prove bad faith on the part of the police. I believe they're asserting that the van evidence was not suppressed on purpose if no one was ever arrested for those crimes, and plus, they weren't crimes Peterson was charged with himself. One of the main reasons the DA is denying Peterson's request for further DNA testing is because they said that when testing was done in 2019, it indicated male DNA was found. And the DA wrote, "There is no legitimate DNA test that would turn the male profile into a match for Laci." However, I find this statement very troubling because I guess the prosecution forgot their own second-degree murder charges against Scott Peterson, since he was sentenced to death for the second-degree murder of a male victim, his own son, Connor. Now, here's what I don't understand, and maybe because I don't work for a DA's office, I understand not wanting to put the family through that trauma all over again. But still, as a prosecutor, wouldn't you be thrilled at the notion of another organization kind of swooping in to pick up the tab to test DNA evidence to help solve one of your unsolved crimes? You know, you're admitting it's unsolved in your community. No one has stepped forward regarding the blood on that mattress. So I would think that getting justice for that unsolved crime would be more important potentially to a prosecutor than to protect a victim's family from more trauma of a supposed solved crime. A huge question that still dangles in the air for me. I have not heard of any other missing people from around that same time frame in Modesto or in that area. So whose blood was in that van? Who tried to destroy all that evidence by burning it? And does that victim deserve a deeper investigation? Now, on top of the idea of not doing DNA testing on an unsolved crime, the original fire inspector who worked on the burned van bloody mattress investigation, he wants to see this DNA tested. Mostly because he knows he got a presumptive positive result when he did the test back in 2003, because he claims it came up positive for human DNA with the Modesto police chief present at the time that he got that result. Yet the fire inspector recently discovered that the Department of Justice actually completely not only mislabeled the initial samples he submitted as not having DNA, they claimed that he was present when they did that DNA testing when it came up negative for human DNA, which he has come out and said that that is completely false. So again, the fire inspector is now really wanting to see these items tested properly, since it doesn't seem like it was done properly in the first place. One of the lead investigators in the case, now retired Detective John Bueller, says that he too wants to see this DNA tested.
What do you make of this van with the alleged human blood stain?
Chris, it is new information to me. I hadn't heard anything about this before. And if we missed it, that's on us. There's always a possibility we can miss things, and we do, but that's what the system is designed for. My feeling is, and I'm sure Mark's feeling is the same thing, test it. Let's see what we got there.
And finally, and probably most importantly, at least one of the jurors who convicted Scott and sentenced him to death has come forward and publicly stated that he wants to see the DNA tested.
I'm glad that this group is taking up the Peterson case and investigating it, because if there's new evidence that suggests he's innocent, then he's innocent. If he is found innocent or not guilty, that'll open up an entirely different emotion, because here we would have a man who has spent 20 years incarcerated for something he didn't do.
Now, after the DA's opposition was filed on April 24th, the LA Innocence Project had a little over a week to reply, so that the judge has enough time to review everything before the upcoming DNA hearing on May 29th. And in that reply, which I have only really had in my hands for a few days now, there is even more, I keep saying mind-blowing evidence. I don't even know another word for it. Mind-blowing information that has come out regarding this case. It's new stuff that I have never heard before, and may potentially be things that have never been made public about the case, because now the LA Innocence Project has this big team of lawyers who are actually sifting through evidence that could have potentially been missed from the beginning, or just not connected properly to the new van evidence until now. And there really was a lot of new info. So my plan was to cover some of that new info in a new series of upcoming videos, sort of the same way I did for the original motions, because it is just so much that they need to be broken into separate videos. But for now, I really just wanted to get out this brief overview of the DA's opposition to the DNA testing before the upcoming hearing on May 29th. And I also just really wanted to hear your thoughts regarding the DA's opposition. What do you think of that? Do you think this is just another way for Scott to manipulate the system, or do you think the LA Innocence Project has a legitimate point wanting to test this evidence that may have been overlooked at the time of trial or suppressed? Do you think the judge should deny these requests to test the evidence, or do you think that she should order the tests? Let me know what you all think in the comment section down below. And in the meantime, I will continue to try and release some of the new information from the LA Innocence Project reply as soon as I can. And finally, I just wanted to take a second to thank all of you for watching and for all of your support. I do see all of your supportive comments, and sometimes I am so overwhelmed by how kind you are that I kind of shut down. I'm really working on realizing that I am worthy of such kind compliments, because for a long time I didn't think that I was. So I'm still working on that. But I'm also still working full-time for a life-saving nonprofit, completely unrelated to true crime, and I've been working there for 18 years. And it's just another passion of mine to help people as much as I can. And some of you know that I'm also a divorced mom of young kids. So it sometimes gets completely overwhelming for me to try to juggle all of these things. And I truly, truly appreciate your patience as you hang in there with me and support me as I try to report on these stories really as quickly, fairly, balanced, and as accurate as I really can to give these stories life. And I really hope to get to a point soon where I can do these much more frequently and much more of them. So please stay tuned while we grow and be patient with me. There is so much more I want to share with you. On that note, if you've gotten any use out of this video, please subscribe so we don't lose each other. It costs nothing and would mean so much to me to have your support along the way. Thank you so much for watching. Be careful out there.